Okay, welcome back. Now we are going to take a look at a very controversial issue, being the involvement of agents and then lawyers in the question of tenancy relationships here in Enugu State. I have gone through the relevant provisions of the law, and there is no express prohibition on agents being involved in the question of tenancies. Interestingly, the Landlord and Tenant Law of Enugu State actually empowered a landlord to create a landlord-tenant relationship through an agent. But for that to be done, there has to be an express authorization on the part of the landlord, for the tenant to act on his behalf. Or when the entire circumstance of a given case is examined, it could be inferred that the landlord empowered the agent to act on his behalf in creating such a relationship. Now, having said that, the nature of agents that a landlord may reach out to for him to, enter into a tenant relationship with him, I think is not the type of agents we are talking about, being the professional agents. Those who normally serve as intermediaries, in fishing out existing properties for prospective tenants to occupy in Enugu State. Now, I have to go beyond law. It may be a difficult task for the government of the state to regulate the activities of these agents presently. I appreciate the fact that nobody is above the government. Yet, in some situations, to achieve positive results, one has to be realistic and one has to adopt a more proactive and pragmatic approach in addressing some issues. Having said that, one may be quick to argue that yes, that these agents, when they do their work, that they don't force you to patronize them. And I also know as a fact that there are some landlords who don't even like working with these professional agents. They don't like having them, near their property. Yet, there are other landlords who don't care much or who exhibit indifference as to the activities of these agents. The most important thing is that whoever approaches them, who is in need of any property, they will tell the person their own terms and conditions before deciding on whether to give out any property to such prospective tenants. Having said that, I would suggest that the government of the day should, through the House of Assembly of Enugu State, take a critical look at the activities of agents and landlords to make it more formal, to determine the nature of services to be rendered by these people. Then, if their services could be done away with, which I doubt whether it will be possible for such services to be done away with in reality. If not possible, then to streamline their activities to ensure that, I will come out of lawyers, to ensure that agents do not embark on the fleecing of prospective tenants, because that's a complaint, the type of charges these agents charge from prospective tenants, to ensure that the prices for their services are regulated, to ensure that prospective tenants are not made to undergo undue hardship because of searching for a place of residence here in Enugu State. So in a nutshell, there is no law expressly prohibiting the activities in Enugu State. Rather, there is an indirect provision of the law that even empowers them to act, even though that law does not envisage professional agents as we know them. Now, coming to the activities of lawyers, the same way there is no law expressly prohibiting tenants from operating, there is no law also expressly prohibiting lawyers from being appointed attorneys by landlords. Interestingly, the Landlord and Tenant Law of Enugu State expressly empowers a landlord to appoint an attorney to act on his behalf while creating a landlord and tenant relationship. And it's also not a must that an attorney must be a lawyer. Let me repeat, an attorney must not be a lawyer. A landlord of a property in Enugu State can appoint any adult person to act as his attorney to represent him, in which case that attorney, just like an agent, can enter into a landlord and tenant relationship on behalf of the landlord can even sue in court or be sued on behalf of the landlord. But it is vital to know that for an attorney to do anything, it must be for the benefit of that landlord. That's why even when a lawyer is appointed an attorney over a property in the Enugu state, if a dispute arises over the landlord-tenant relationship, that lawyer cannot sue in his name, strictly so-called. That lawyer must sue in the name of the landlord and then stay by attorney. Let's say Mr. Okeke by attorney, by his lawful attorneys, CD Obe Esquire or JJ Obe Esquire. Even though there's no, I don't think there's any lawyer who goes by the name JJ Obe. I'm just trying to give an example. But most landlords normally prefer making use of lawyers as their attorneys because of the fact that in the event there is need for recourse to litigation, such lawyers appointed as attorneys will now be the ones to handle such cases. Now there's a crucial question that most tenants normally ask: the issue of 10% of the services, for the services, legal services being rendered by lawyers. Now let me clarify that issue. The 10% that most tenants normally raise is the money being paid by the landlord to the lawyer or to the attorney. Ordinarily, a tenant does not come into the picture in this regard. It is the 10% for the services rendered to the lawyer, by the lawyer to the landlord for managing the landlord's property. Let me repeat. For instance, if I'm appointed as a lawyer over a property, I may enter into an agreement pursuant to the instrument through which I was appointed to manage this property, that for every services, for every rent being paid by a tenant, maybe on a yearly basis, that 10% of the money paid as rent by these tenants will be given to me by the landlord as professional fees for the services which I render. So the 10% is between the landlord and the lawyer. The tenant does not come into the picture. Now, I know the second question is this: how come lawyers demand money from tenants or from prospective tenants apart from this 10%? For instance, you find a tenant who wants to move into a new property, and the landlord will be telling the lawyer will be telling the tenant to pay 100,000 naira as legal fee or 50,000 naira, or any other amount of money as the case may be. The logic behind that is this: that money you are paying to that lawyer is for his legal services. Of a truth, it will not be fair for a lawyer who is managing a property to collect money from both sides. What do I mean by both sides? Collect money from a tenant who is moving to the property, being the one-off legal fee, and also to be collecting money on a intermittent basis from the landlord for the professional services which he renders to the landlord for the property which he manages. But if you want to enforce the strict provisions of the law in this regard, it will also be counterproductive if you have to be realistic. It may be difficult, clamping down on lawyers who embark on this line of action, because in the first instance, the lawyers will want to argue that they never consulted you, they never told you to reach out to them, that the agreement they prepared is the legal services which they render to you, which you are not being compelled to embrace. And in which case, if you do not want to embrace the legal services which they are rendering by preparing tenancy agreement, that you are free to offer any other property. I'm just trying to be realistic with this particular scenario. Let me repeat. The lawyers will argue that the tenancy agreement which they prepared is deemed to be that you consulted them to prepare an agreement for you that will embody the terms of the landlord-tenant relationship which you are entering into. In other words, even if I'm not employed or even if I'm not engaged as an attorney by the owner of a property, a tenant can consult me as a lawyer that I should please couch a landlord-tenant relationship because it's in form of a contract that will embody the contract that I'm entering into with the landlord. Likewise, a tenant can also contract, a landlord can also reach out to me that I should, can also reach out to me to prepare a tenancy agreement for his prospective tenants, in which case the landlord will not pay me for the tenancy agreement prepared. So the money these lawyers normally collect, we lawyers normally collect, ordinarily is the money for that tenancy agreement prepared. Most of us, that's where we make our money from. So if you want to start applying logic, most lawyers will tell you no problem, that they are not giving out the property. So these issues are coming on the heels of the paucity of accommodation. We have fewer accommodation, and those who are in need of accommodation far much outweigh the number of available accommodation in town. I will also suggest that the government should also come into this issue. The government should not sit back and watch. The government has to be more realistic to say, okay, that they will not sit back and watch. Let us play the amount of money that should be collected instead of making it to be open-ended, because we run a capitalist economy, and in which case ordinarily the forces of demand and supply regulate these issues. But it's having an adverse toll on the vast majority of the populace here in Enugu. So there should be some form of compromise to be reached by both parties, with government coming in to regulate the entire transaction. Just like what was the case when the rent tribunal was very effective here in Enugu State, portion to the landlord and tenant law in Enugu State. Despite being driven by the forces of demand and supply in Enugu State, yet the law then empowered the government to say that, okay, for those who occupy so and so caliber of properties, so and so parts of Enugu, that the benchmark, the so and so amount of money should be paid as rent. A landlord can decide to collect a lesser amount of money, or even an amount of money that is slightly above that benchmark, yet you cannot go far beyond that. For instance, if the government of the day stipulates that those who occupy three-bedroom flats in a place like Achale out should be paying 300,000 naira, a landlord may decide to collect 250,000 naira from a prospective tenant or from a tenant. Likewise, a landlord may also decide to collect 320,000 naira because it's within the benchmark stipulated by that law. Because that law normally provides for a range within which rent is to be paid. This should also apply to the services. The money is being collected by lawyers and tenants. Clamping down on them entirely may not be feasible. But the government can come in to regulate the amount of money to be collected and then enforce it. In which case, whichever way you look at it, every rational thinking human being with conscience will say, okay, this amount of money is rational, it is reasonable, it is not exorbitant. The law could provide that, okay, for so and so nature of property, that agents should not collect more than so and so amount of money, and for so and so property, lawyers should not collect so and so amount of money. In a nutshell, the law does not stop landlords from using tenants and from using agents and landlords in managing their property. The law does not stop them in Enugu State. Only that the activities of some of or most of us lawyers and agents are exorbitant and detrimental to the interest of tenants. I wouldn't want to delve deeply into the reasons being given by some lawyers, or even, basically by some lawyers for the services they charge, because if you take a look at the 10%, for instance, being collected or being paid by owners of properties to landlords, being landlords to lawyers, you will discover that when disputes over the management of that property arises and lawyers go to court, that if landlords should start paying them what we refer to as appearance fees for every day they appear in court, the landlord may end up losing out. Likewise, the lawyer will also end up losing out. Let me explain better. Ordinarily, the cheapest amount of money a lawyer may collect from a landlord in going to court in a day as appearance fees, 5,000 naira. And now, let's say that the entire money paid a lawyer in a year from the 10% is 200, or let's say 200 or 300,000 naira. And then there are 2 or 3 tenants giving problem in the property. And then maybe to prosecute a given case, the lawyer, apart from the money being used in filing the processes which will be provided by the landlord, the lawyer spends, let's say, a period of 6 appearances in prosecuting a given case, or let's say 8 appearances if the lawyer is lucky. 8 by 5 with 40,000 naira appearance fee only. We haven't talked about the monies to be used for the service of the processes, filing of the processes. I wouldn't want to mention that particular amount of money that may be spent at the end of the day. You find out that the landlord may not be comfortable paying a lawyer such amount of money. in evicting a tenant. And even when judgment must have been gotten, the monies that will be spent in even executing judgment of the court of law. So these other monies, these are avenues through which they recoup and also make profit. They recoup, the expenses they incur in protecting that property, so to speak. But I am not trying to justify that practice here. I'm trying to bring to our knowledge, some underlying factors that may be behind some of these charges being collected from prospective tenants. By and large, I still insist and submit that there is need for a comprehensive overhaul of our law while bringing into force the realities of the moment. Even some of these lawyers who accord attention to property management, the reality on the ground is that if the economy of Enugu State is thriving very well, some of these lawyers may not have any business in property management. I repeat, some of these lawyers may not have any business in property management. If the economy of Enugu is booming like that of places like Onitsha or Lagos, lawyers will have other profitable ventures they are calling attention to. Basically, many lawyers in Enugu tend to find property management as an avenue through which they eke out a living. I am also not trying to justify the activities, but I'm being realistic while hoping that the government of the day in Enugu State will take a holistic view of some of these issues and know the best way to marry the interest of tenants, landlords, agents, and lawyers, so that the various facets of these particular controversial issues will be taken care of. Now, the duties and responsibilities of landlords and tenants when the tenancy is being created. I have highlighted some of these issues before. Basically, it has to do with terms and conditions. Duty to manage the property, duty to take care of property of a landlord, for him not to fall into disrepair. The duty imposed on the tenant, on the landlord, to ensure that the tenant enjoys quiet possession of the premises. Don't disturb the tenant recklessly. You should allow him to enjoy his property. There's also a duty imposed on a tenant. You pay rent. You pay your rent to your landlord, because if a landlord does not want that rent, he may not actually let that property. He may just use that property for personal use. But it's a commercial venture, and that being a commercial venture, he expects that you're paying rent. There's also a corresponding duty on a landlord to issue receipt to a tenant. If a tenant pays rent, you issue receipt to that tenant. It's that tenant's entitlement. However, when a tenancy is determined, when I mean a tenancy is determined, when a notice to quit is issued and served, a tenant is automatically not entitled to receipt when he pays rent. What that tenant will not be entitled to is evidence of payment of rent, evidence of payment of what we refer as mean profit. In other words, the money you pay a landlord once your tenancy is determined is called mean profit. It is spelled MEANSE, and it is pronounced mean profit. So in which case a landlord can make a remark on the document issue saying that this money received from so person is serves as mean profit for the property which which he occupies after the tenancy has been determined. So these are basic duties and responsibilities. To keep the property in tenantable repair, the property has to be neat. You as a tenant, you are not expected to use the property for any purpose that is a variance for that which it was left out. If at the initial stage that the property was given to you, it was to be for residential purposes, you are not expected to convert it into a business premises. Likewise, as a landlord, you are expected to pay property rate. But that's the business between you and the government. It's not the business of the tenant. But if the chance the government disturbs a tenant, and because of such incessant disturbances being suffered by a tenant in the hands of the government, the tenant decides to pay a property rate. The tenant in law can come after you legally as a landlord for you to reimburse him the money which he paid to the government that serves as property tax or property rate. It is the duty of a landlord to pay property rate. Now, the biases and prejudices against landlords and tenants. I've also highlighted that in a nutshell. You know, this underdog syndrome, this is the bias against landlords. Many persons believe that all landlords are horrible people, and then that all tenants are good people. It doesn't work that way. There are many horrible landlords. There are also many wonderful landlords. Likewise, there are many horrible tenants and also many wonderful tenants. You know, human beings, due respect, are very difficult creatures. This law office, we are into property management, and we see a whole lot of things. We have come across landlords who are not good. We have also come across tenants who are not good. There are tenants who are ordinarily troublesome. And you know, some of these issues, even issues that bother on the charges being made by lawyers, they emanate from the activities of some of these tenants. Because in prosecuting them, you spend money. In prosecuting these tenants, I'm not talking about tenants who, there are tenants who are usually indebted to their landlord, but they are not bad tenants. We know such people. They owe their landlords. Yes, I know that an average landlord will always be in need of his money. But there are tenants who are very wonderful people who live in properties for a very long period of time. They are being troublesome. They are good to co-tenants. In fact, most landlords love having such tenants in their premises. Yet, the vicissitudes of life, the realities of life may step in. Such tenants may lose their jobs, and you find it difficult having them pay their house rent. And you now find the lawyer in a tight corner, trying to meet up with the expectations on the part of the landlord, you know, the landlord's rent, and also putting into cognizance the predicament of the tenant. So, in such situation, as a lawyer, if you don't do your work, you may lose your job. Likewise, you have to exhibit sympathy as a human being for such a tenant. So, these prejudices and biases, we have to look at every case on an individual basis. There are landlords who love extorting tenants. Apart from the basic initial payments being made when tenants are looking for properties, there are landlords who ordinarily love extorting tenants. It is not good. Apart from whatever the law says, it is not good. It does not make any sense extorting tenants. Apart from whatever legal provision, legal step a tenant may decide to take, or being unnecessarily difficult. You know, as I said earlier, to manage human beings is a very difficult task. I say that from experience. In fact, some of us lawyers, we don't even like managing properties because a whole lot of things happen here. At times, after having a very hectic day, you may receive a call with regard to maybe crisis between tenants over a property that you manage. We've come across instances whereby tenants even fight one another. You know, in this case, you have troublesome tenants who go after themselves. Tenants who embark on malicious and deliberate the destruction of the properties of landlords. Tenants who bring in criminal elements into the properties of landlords. Tenants who use their property for criminal purposes without the landlord being aware of that. And that's where we come in, we become handy as lawyers. So it has to be striking a balance. Being a famous lawyer, yet being considerate. For those who are troublesome, you go after them. When I mean troublesome, for those who are criminal-minded, for those who are inherently troublesome, for those who are horrible, there are some tenants who are very, very horrible. But as I said, underdog syndrome, whenever there is a crisis between the landlord and the tenant, many people tend to lend in favor of the tenant. But it doesn't work that way. So we have to look at every case on individual basis. Because many tenants who are listening to me, we also attest to the fact that there are many wonderful landlords. There are landlords who even assist their tenants financially. There are landlords who live with their tenants like brothers and sisters. And I encourage that. In as much as I also encourage tenants to also reciprocate. I know some landlords who, because of their good nature, tenants who live in their property at the end of the tenancy, they still come back to recognize them, to appreciate them. They still communicate with them. They still maintain that brotherly relationship. But we must learn to balance these divergent issues. Then finally, the issue of rent. Rent is the consideration, what you give to the owner of the property. It may be by way of services, legal services rendered to the owner of the property. For instance, if I'm a technician, maybe I know how to repair television sets. The landlord may say, okay, instead of paying house rent, you can repair this television set of mine for this month. It takes care of your house rent for this month. It becomes consideration, valuable consideration. Now, rent is paid in arrears, subject to agreements entered into by parties in Enugu state. Let me explain. If I'm a monthly tenant, I'm expected to pay rent at the end of every month, the last day of the month, subject to the agreement. If while entering into a tenancy agreement, we agree that I'm paying rent in advance, then I'm paying that rent in advance. In other words, to solve most of these controversies that normally emanate from landlord-tenant relationship in Enugu state, it is good that parties put in writing the terms and conditions which they want to govern that particular relationship. It will help take care of a whole lot of controversies that we normally witness every now and then. And then the amount to be paid as rent is also dependent on the agreements reached by both parties. And I'm using this opportunity to call on the government of Enugu State to come into this particular issue of rent, for rent tribunal to be brought back to life, so that the exorbitant rents will be checkmated. I am a lawyer, of course. I manage property. Then there is a limit to what I can do as a lawyer. Of a truth, it's no child's play to be the property presently in Enugu State. Building materials are very expensive, and that's the argument that has been put forward by many people. That if the government of the day wants to checkmate the increase in house rent, the government should also endeavor that Enugu is decongested. There should be other satellite cities in Enugu State, so that this densely populated nature of this city will be taken care of. If we have satellite cities, then people will now be compelled to live outside the shores of Enugu municipal. And it's not just about having satellite cities. In creating those satellite cities, provisions should be put, or job opportunities should be created in these various satellite cities, so that most people will not have reasons coming to Enugu urban to carry out to make a living. And the culture of greed should also be addressed in Enugu and other Nigerian cities, because at times when we accuse landlords of embarking on reckless increase in rent, we normally accuse landlords while keeping mute on our own greedy activities. Most of us are greedy, not only the landlords, because at times when we tend to intercede, when we tend to appeal to some landlords to exercise restraint in the manner in which they increase their house rent, they'll be quick to tell you that these other people also increase the prices of their goods and services. So most of us are greedy, not only the landlords. Just like what happened in this country some weeks back with the introduction of the cashless policy of the central bank. Many POS operators saw that as an avenue to fleece many Nigerian citizens. So there is this culture of greed going on in our society. So the government should try to ensure that industries saddled with the manufacturing of equipment used in building houses, that such industries are created and made to thrive well in Enugu, so that building materials could become affordable. Because if it's easy for people to build their own houses, many people wouldn't mind staying on their own, no matter how little such accommodation may be. Then the government of the day should also create room for mortgage facilities. These estates being built, low-cost housing estates should be created by government, should be built by government, so that low-income earners, subject to the availability of mortgage facilities, could, procure their own houses. And in that case, some of these issues will be taken care of. But by and large, before that will be done, I think it's necessary for the government to come in and to wade into this issue of rent. Yes, we are in a capitalist economy, yet there should be a benchmark that resonates with common sense. We all are human beings. That's why there are some landlords at times, I raise this issue that yes, you have the right to increase your house rent, Yes, why doing that? We are humans. We have conscience. Don't bother about what your fellow landlords do. Opt for a rent that resonates with common sense. Opt for a rent that resonates with good conscience. You know, this goes beyond law. Whatever you do as a human being, you should do that while exhibiting sympathy. Yes, it is expensive to build a house. Very, very expensive. I appreciate that. We appreciate that. We haven't said that you should give out your house free of charge. But there's an amount of money that you will collect from tenants that anybody who hears about such an amount of money will know that it resonates with common sense, in all fairness. So I hope you must have learned one or two things from this interaction. If there's any issue that you would like us to address, which we haven't addressed, feel free to ask your questions. You can subscribe to the YouTube channel, being CD Owe TV. Then you watch this video, then you ask your questions. We will hopefully attend to your questions and concerns. Feel free to also invite your friends to also watch these video clips, which you have prepared in a various segments, so that at least we appreciate the ambit of the rights of landlords and tenants in Enugu State. Thank you very much for your time. Thank you very much for listening to me this wonderful afternoon, this wonderful 22nd day of May 2023. See you this time next week as we take a look at another part of this interesting discussion, being the determination of tenancies. When I mean determination of tenancies, how can this landlord and tenant relationship be brought to an end in the Enugu State of Nigeria? Thank you very much. I remain myself, CD Owe Esquire. That is Chukwuna Daniel Owe Esquire, the principal counsel in the law firm of Chukwuna Daniel Owe and Company, Victoria Ascenta Chambers, Enugu State, Nigeria.